Welcome to Courtside Commentary, where we're going to dig into the upcoming oral arguments at the U.S. Supreme Court in the tariff cases against the Trump administration. And here to discuss those cases and the upcoming oral argument, I have a special guest, Steffen Johnson, an old friend of mine who is not just one of the co-authors of the brief for VOS selections in one of the pending cases at the Supreme Court, but is also the nationwide chair of the Supreme Court and appellate practice for Wilson Sonsini, and was at the Department of Justice in the Office of Legal Counsel, where Steffen worked on a lot of executive power issues and developed some of that expertise that he is bringing to bear in this case. And that was during the George W. Bush administration, where we have overlapped for a year or so when I was in a different office at DOJ. So let me just start, Steffen. Tell us about your clients. Who is VOS selections, or some of these other clients you're representing? Are these Fortune 500 kind of companies, or?
Not quite, no. These are small businesses that are doing all kinds of wonderful things in our economy. VOS Selections is a wine importer. One of the companies does women's cycling gear and equipment. It's kind of a wide array of small businesses doing unique things, and of course, they're dependent on imports.
Sure, and they're the ones paying the tariffs, right?
That's exactly right.
Yeah.
They pay these taxes.
Sure. So tell us about the tariff case before the Supreme Court. I think that folks who've been paying attention are maybe aware of two of the cases. There's your case, the VOS selections case. There was another case that came up from the district court in D.C., the learning resources case, and that's I guess that's the lowest number at the Supreme Court. So that's the shorthand that all these cases sort of gets assumed under learning resources. But then there was also a third case, I guess, brought by some of the state attorneys general. Is that right?
That's exactly right. So there are three cases pending before the Supreme Court. The state's case is unique in that they challenge not only what we call the trade deficit tariffs, but the fentanyl tariffs. So really all the tariffs imposed under IEEPA.
Okay.
State's challenge is broader in that sense. They're led by Oregon. There are 12 states. And then there are two cases brought by private parties, our case, the VOS selections case, and the learning resources case, as you said. You may ask, well, why do they need three cases? And the reason is that there's an issue of jurisdiction in the cases. Our case was filed in the Court of International Trade, which has exclusive jurisdiction over whatever the scope of its jurisdiction is. It's exclusive. And so we argue, and the government actually agrees with us about this, that this case was rightly brought in the Court of International Trade, and the other cases, and I know you all have a case like this.
Right. We got sent to the Court of International Trade, but it's not where we want it to be.
And so this other case was filed in federal district court, and that case actually had not yet reached decision in the D.C. Circuit Court of Appeals, where it was headed. Court reached out, took it before the D.C. Circuit ruled, and the obvious reason is that obviously this is a case of great importance, and they want to be able to reach the merits. So one way or another, whoever's right about jurisdiction, the court will be able to decide the validity of the tariffs.
Are there any significant, other than jurisdiction, are there any significant differences between the views of the private respondents here and the attorneys general?
I mean, I would say in broad outline, the arguments are similar. Certainly, we emphasize some things more than the other parties do. Our brief talks more about the non-delegation doctrine. I think the brief for the learning resources parties talks a bit more about the Constitution's ban on taxing exports. Okay. And this we'll get into a little bit. The statute talks about regulating importation or exportation. So, there are some differences at the margins. For most people's purposes, they're not huge.
Well, let's jump into that. So in terms of what the two sides are arguing, I mean, you were saying before, this is really a matter of first principles in terms of where your client comes down on this.
Yeah, I mean, so, your audience has read about the separation of powers, studied it in school. Those who are lawyers, remember a case called Youngstown, the steel seizure case. And, the Supreme Court has explained, and it's evident right in the text of the Constitution, each of the branches of government has power that's vested in them. And the Supreme Court said in Youngstown that the president's powers either need to derive from the Constitution itself or from some statute, basically Con Law 101.
Right.
And so it's common ground in this case that the president doesn't have independent authority under the Constitution to impose these tariffs. So it's all about, what does the statute say? What authority does it give him? And the president is relying on a statute called IEEPA. of 1977. And he says that a phrase in that statute that says he can regulate importation or exportation authorizes him to impose tariffs, which of course are a tax.
So regulate means tax. That's the position of the government.
That's essentially the position of the government.
That's a scary position.
One of our arguments is that, the idea of regulating mean tax could potentially have just extraordinary implications for the U.S. Code. It would sort of supercharge the president's powers under the U.S. Code because, the U.S. Code authorizes the president or people under his authority, secretaries of the various
right.
departments and so on, to regulate everything from cigarettes to cars, to whatever, A to Z.
Right.
And so if those are authorizations to tax, that's a much different and broader power. And we argue that, going right back to the Constitution, there's a distinction between the power to regulate and the power to tax. And the very first power given in Article 1, Section 8 is the power to lay and collect taxes or duties and various other terms like that.
Right. Imposts, I think.
Imposts. Yeah. And that is exactly what's at issue here. It's given to Congress. And so that's why the president's
It is an enumerated power of Congress.
It is the first enumerated legislative power in
right.
Article 1, Section 8. And of course, all of the legislative power under Article 1, very first sentence of Article 1 says the legislative power is vested in Congress. So that's one of the issues once we get past what the statutes mean. We say, look, if you reject everything we say about the statutes and you really think the president has this broad of authority, it's actually giving him legislative power. That's unconstitutional.
Right. And I mean, we would say that at NCLA that he has no inherent executive authority to issue tariffs. And if IEEPA, which is the only statute that he has invoked, also doesn't give him legislative authority to invoke tariffs, then he doesn't have any authority
left.
Right.
It all comes down to IEEPA, and that's, you could say it different ways. You can talk about inherent authority, independent constitutional authority. The bottom line is both sides agree in this case that the president's authority derive from what he's been given by Congress.
Right.
And the only statute that they invoke, the government invokes, is IEEPA. And really, it's one phrase. It's regulate importation or exportation.
So it's really IEEPA or bust.
It's IEEPA or bust.
In terms of whether or not there's authority for the president to do this.
That's right.
So let's talk a little bit more about this phrase, the regulate importation or exportation. Why, from your vantage point, is the administration wrong that gives the president a tariff authority?
So just starting from the narrowest we'll start narrow and pan back.
Sure.
Look at the phrase regulate importation or exportation. The ordinary meaning of regulate is not tax, as you've alluded to. I mean, if a legislature said to an agency, we give you authority to regulate the inflow of cars by charging a toll, then you'd think, okay, they can can charge a toll. That's effectively a tax, right? But if the legislature just says the agency can regulate the import of cars into the city, you might think that was safety standards, make sure that unsafe cars don't come in. You might think it's quotas, make sure too many cars don't come in. It doesn't bring to mind taxes.
Right.
And of course, there's a long history of Supreme Court decisions saying, really going back to at least the 19th century, saying we don't lightly find taxing powers. If it's ambiguous, then there's no power to tax. Congress has to be clear when it's giving the power to tax.
Right, and it partly is. Not only does the Constitution give the power to tax to Congress, but all tax bills have to originate in the House, which is the part of Congress that's reelected every 2 years. So they were really trying to keep that taxing power as close to the people as possible. Maybe because we just fought a war about taxation without representation.
Might have something to do with that. I mean, James Madison said that the power to tax was the most complete and effectual weapon that the people can give to their immediate representatives. And they put it in the legislature because they and as you've noted, tax bills have to originate in the House. They wanted maximum democratic accountability for taxation. So obviously the president is an elected, he's one of the political branches, right?
Yeah.
I mean,
but it's not a representative office.
That's right. And they wanted geographic diversity. They wanted basically as much representation as possible. The folks who rebelled against King George under the banner of no taxation without representation, they wanted a representative body, a legislature, to decide whether they would be taxed. And although people, I think there's a lot of rhetoric about tariffs, to the point that you almost forget they're taxes, right? But they are taxes, and under the government's theory of this case, the president asserts the authority to set the amount of the taxes, the duration of the taxes, the goods that are taxed, and the countries. That's all something that, under the government's theory, is within the president's discretion, something historically Congress has done.
Yeah, so let's walk through this because I know this goes back to the 1970s and there was a predecessor statute. Walk me through how that whole logic plays out here with regard to the International Emergency Economic Powers Act.
Their first response is, well, actually, this language has a particular history here.
Okay.
It traces to the Trading with the Enemy Act, which President Nixon didn't invoke it, but the Justice Department invoked it when he imposed some tariffs.
When someone sued over it.
There was a lawsuit over it in the 1970s. So what happens is in 1971, President Nixon is facing a crisis related to coming off the gold standard. People were showing up and saying, basically, give us gold in exchange for American dollars. And there was a balance of payment and trade deficit type of issue related to this problem. And the president, he actually invoked a couple trade statutes and said, I'm going to impose tariffs. They're going to be for 10% and they're going to be for 5 months. Naturally, the people who paid them felt that, we don't want to pay these. They brought a lawsuit. In 1974, the Customs Court, which is the predecessor to the Court of International Trade now, which our case came out of, said these are unlawful tariffs. So it was in 1974. It's a little detailed, but I think I can make it clear.
Yeah.
A couple months later, Congress enacts the Trade Act of 1974. And the legislative history shows they were aware of this Customs Court decision, and they said, in light of this, we are giving the president specific authority to deal with these sorts of trade deficits, balance of payment deficits type of situations, and we'll give the president a little bit more than Nixon used. We're going to give him up to 15% surcharges, but same amount of time, 5 months. So a very specific response in Section 122 of the Trade Act of 1974 to deal with the problem that Nixon had sought to address.
And that was prospective. Going forward, he could do this. This wasn't just ratifying his previous actions.
That's exactly right. And it was, of course, after the Customs Court had said, you can't do this.
Right.
Well, so Congress acts, provides specific authority, but the government appealed the Customs Court's decision. It goes up to the Court of Customs and Patent Appeals, which is simplified
sort of like
a bit,
the Federal Circuit.
The predecessor to the Federal Circuit, and they reverse in 1975, and they say that these folks are not entitled to refunds because that was the question that remained.
Okay.
But they said some very specific things. First of all, they said these are limited and temporary tariffs that are not done in a way that's inconsistent with the congressional tariff schedules. Congress has enacted
didn't exceed whatever limits.
Didn't exceed the limits, and the tariff schedules are actually statutorily created charts of who pays what.
Yeah, very specific.
And they're quite specific. And the court said this is limited, this is temporary, and it's not in disregard of the Congress's will because it's within the amounts of the tariff schedules. And they said, in addition, going forward, of course, the new law will govern. And they said this is not a claim of unbounded authority or unlimited authority. That would be problematic under the Constitution as a excessive delegation of legislative power. So several things they said to kind of limit the scope of their holding. So then, that's 1975. A couple years later, Congress has now enacted a comprehensive trade law, the Trade Act of 1974, which established things like, the fast track authority that you hear about. It really was kind of ushered in the modern era of trade law for the United States. But they've done this. So they come along in 1977 and they act IEEPA, and they repeal the Trading with the Enemy Act as applied outside of wartime, which is the statute that this language had come from. And they give the president some powers to do things like asset freezes and embargoes and so on in IEEPA. And that's where the regulate importation language is repeated then as among that list of powers. This was an era when Congress was generally pulling back on the powers.
Well, this is the post-Watergate Congress, right? They weren't looking to give a lot of executive power away at that time.
That's right. And all of the witnesses basically talked about how, the powers that the president had been given under the pilots had been abused by successive presidents. And they wanted to pile it back to provide more limited powers in the economic context outside of wartime. So the government then says, look, Congress took the soil of this TWIA statute and put it in IEEPA, and you have to bring with it the interpretation, and basically that means that this language that's been repeated gives the authority to impose tariffs.
So why is that wrong?
Well, it's wrong for a number of reasons. First of all, just taken on its own terms, I mean, Congress had spoken very specifically to the problem that President Nixon was dealing with and provided
Balance
authority.
Balance
Balance
of payments.
of payments types of problems, and provided a solution, a very specific solution. And so, to put it in lawyer terms, the specific controls the general, right? You can't rely on general language to do something when Congress has provided very specific procedures you have to follow and limits on you in dealing with a particular problem. That was something the Supreme Court said in the Youngstown case, that it's the fact that you've got additional hoops to jump through, and even in an emergency, you have to comply with the conditions that Congress imposes. So that's part of the reason. Another part of the reason is that there's no indication that Congress really agreed with the statutory interpretation of this earlier decision. And in fact, all the signals, to the extent you think legislative history is relevant to how you decide these things, you look beyond the text, all the signals are that Congress was narrowing the powers that the president had. And then finally, I mean, it's sort of like you got to take the bitter with the sweet. I mean, you can point to the aspect of this one decision, and this is the only decision that the government points to where regulate has ever been held to allow taxing. You want to take that? All right, well, then you have to take all the things that the court said to limit it. This is temporary. There's a new statute on the books that governs. And, and an unbounded power would be, it's not in derogation of the congressional will, and an unbounded power would be problematic under the Constitution. So there's several lines of response.
Okay. Another argument that I see you make in the brief is around the emergency that was declared in this case, because even under IEEPA, the president has to declare emergency in order to use these ostensible powers. So what concern do you have about the emergency that was declared here?
Sure. So, I mean, an emergency, a dictionary would tell you, is something that's sudden and unexpected. So what is the emergency that the president pointed to here? He pointed to longstanding trade deficits. And in fact, 9 separate times in his proclamation, he referred to them as persistent. So you have an emergency itself that's supposed to be sudden and expected. And the idea, of course, is that the general idea is that when you're dealing with emergencies, it's important for the president to have robust powers because there could be unanticipated things, and you need to, the president needs to be able to act. He's one person by design, right?
Yeah.
A legislature moves slowly.
I was going to say when there isn't time for Congress to act, perhaps.
When there isn't time for Congress to act, of course, is a paradigm case where you'd say, you might get more deference. Here, Congress not only had time to act, but did so to speak to the very specific problem we're dealing with, the problem of, to the extent it's a problem, the problem of trade deficits. Beyond the fact that there has to be an emergency, there has to be an unusual and an extraordinary threat to U.S. interests.
These are more statutory terms?
These are more statutory terms under IEEPA.
Okay.
That is an independent requirement. And the way the statute is framed, it's pretty clear that Congress anticipated that is something that would have to be found to exist, independent of whether there might even be an emergency. And so one of the things that we say is when there's been 50 straight years of trade deficits, that is neither unusual nor extraordinary. And, a lot of economists would say that...
Nor emergent. You were talking about it needing to be an emergency. It's just if it's happened for 50 years in a row, it's not an emergent problem.
Right. And now...
You wouldn't go to the ER for this if it were... This is more of a chronic problem than a...
That's right. Now, some would say you could reach a tipping point, but if you look at the numbers in relative terms, our trade deficit as a percentage of, GDP has just remained basically steady. For at least the last decade, So although you could say absolute numbers have increased, when you adjust for inflation and you look at it in relative terms, the government's own numbers show that really there's been no change. So the way we put it in the brief is, maybe in theory, but not in fact.
So is this solely a statutory case, or are there constitutional issues in play here as well?
It's primarily a statutory case, but there are definitely some constitutional issues at play. Of course, the general backdrop is who has the power to tax, right? Then there are a couple more specific constitutional limitations that are at play. One is a little narrower, and that's the fact that the Constitution actually bans taxing exports.
Mm.
And this statute gives the president the authority to regulate importation or exportation. So, on the assumption that the term is not a chameleon and it doesn't mean one thing is applied to imports and something else is applied to exports, if Congress can't constitutionally tax exports, you would think Congress probably wasn't trying to do different things as to the two terms. The ordinary idea of regulate is kind of command and control. Taxing takes lawful activities and makes them more expensive. Regulating is more directing, controlling, putting limitations and conditions on things to either prevent them or restrict how they can happen. So one of the arguments we make is that the ordinary meaning of regulate doesn't mean tax, and you can know that even more so because if it did mean tax, they adopted a statute. You're kind of attributing to Congress the desire to violate the Constitution, and they, like the president, take an oath to uphold the Constitution.
Sure. Another argument you make on the statutory lines here is along the lines of what we call the major questions doctrine. This is something the court it's been around for at least a quarter of a century, but not necessarily traveling under that name. But in recent years, the court has pointed to things like the vaccine mandate or the nationwide eviction moratorium or the student loan debt forgiveness and said, wait a minute, these are major questions, have a significant impact on the economy. We're not just going to lightly assume that Congress was
That's right.
regulating in this area. How does the major questions doctrine overlay with some of these arguments about IEEPA and the president's tariff authority or lack thereof?
Sure. So that's a doctrine of statutory interpretation. Some justices have called it the major questions canon. Congress, the court will presume that Congress wants to do things that are a really big deal for the economy itself and not to delegate the power. So if you have situations where the assertion of executive power would have massive effects on the economy, and then in addition, if the statutory authority is maybe historically unprecedented, or the statutory authority is ambiguous, it's a creative use, a novel use of the authority given, the court's going to take a really hard look. Basically, the idea is it's rooted both in separation of powers concerns, that they want to respect the fact that major legislative decisions are given to Congress under the Constitution, but also just the idea that you would assume Congress isn't going to give away the core of its job.
Right.
And when you've got, in this case, over the next 10 years, this is roughly $2 trillion in taxes. That's a huge deal for the economy. You'd want to have very clear statutory authority. So one of the arguments we make is that,
and that's, for example, 4 times the $500 billion that was at stake in the student loan debt forgiveness cases.
That's
so
right.
We're talking about something even more of a major question than at issue there.
Right. It was $430 billion in the loan forgiveness case, and so this is multiples of that. There's no real argument back from the government on this that this isn't a lot of economic impact. In fact, they boast about the economic impact.
Right.
And which their prerogative. If they have this authority, then they should claim it's doing good things.
One of my colleagues likes to joke that when they lose at the Supreme Court next year, the administration is going to talk about the largest tax refund in American history. So I don't know if that's going to happen
from
or
your
not.
lips to God's ears. Yes. But in any case, so where's the fight? The government says, well, that doctrine really shouldn't apply when the president is acting in the area of national security and foreign affairs. And that's a thread that runs through their whole position in this case. The other thread that runs through their brief is that the president should get extra deference on matters of national security and foreign affairs. And we respond, essentially by saying, well, look, tariffs are taxes on the American people.
Right.
And that power
These are paid domestically.
The first legislative power given to Congress. So it's not like the president's ability to go negotiate a treaty over defense cooperation, where he's operating as commander-in-chief. As Justice Jackson famously said in a concurring opinion in the Youngstown case, the president is commander-in-chief of the armed forces. He's not commander-in-chief of the country. And so historically, the court has been, I think they've given the president pretty robust control over, for example, operating his own executive branch. But when you start to regulate the private sector, some different limitations kick in.
Sure.
And so this is domestic in many ways. Congress viewed it as its exclusive prerogative until well into the 20th century. And everything they've done since then has been very tightly circumscribed. So they do give the president tariff powers, but they're pretty strictly limited. So that's, one reason why we don't think it's fair to just say, basically the government defines foreign affairs too broadly.
Sure. Well, let me ask you this. I mean, I know the answer, but our audience may not. How many other presidents over the last 50 years that IEEPA has been around have invoked it to impose tariffs?
It's never been used to implement tariffs.
So this is an unprecedented use of the statute 50 years down the
IEEPA
road.
has never been used to impose tariffs in its roughly 50 years of existence.
To me, that's a compelling argument, in part because that's a similar situation that we had with the HEROES Act and the student loan debt forgiveness. Is no other Department of Education had looked at that language and said, oh, this means we can do all this debt forgiveness. The fact that you have this longstanding interpretation or practice at the with regard to IEEPA from Carter, Reagan, Bush, Clinton, Bush, Obama.
Well,
First Trump administration didn't do it either, and Biden, and now for the first time they're trying to do it. It just seems like that's less likely to be persuasive to the court that, because it's foreign policy, we should get deference here.
Well, and indeed, not only did they not interpret IEEPA this way, they specifically went to Congress. President after president after president went to Congress and said, give me authority to negotiate these trade agreements. And under the fast track system, you go in advance, you get authority, and then Congress does an up or down vote afterward.
Right.
So there are various mechanisms to impose different types of tariffs, and there are mechanisms for the president to negotiate trade agreements. And I'm certainly sympathetic, with the idea that, we shouldn't be taken advantage of by our foreign adversaries, but
Sure.
Obviously you have to have statutory authority to do it.
If you do prevail, though, couldn't the president just levy taxes under another law and turn around and, what would be some of the restrictions in those scenarios? For example, couldn't he just go to Congress and ask them to ratify what he's already done in these cases?
Well, there's certainly ways that the president can negotiate agreements and get Congress to approve them. As I referred to earlier, the statute that most specifically speaks to the problem that the president cited in his proclamation, the problem of trade deficits or balance of payments deficits, is Section 122 of the 74 Act. And that would hem the president in much more than what he's done, because it limits him to 15% surcharges and 150 days. So there are, of course, those aren't the only statutes available to him. There are statutes that deal with national security threats. There are statutes that deal with situations, effectively you'd call them dumping, where you've got products being put into our market that are threatening domestic industry unfairly. So there are several different avenues that Congress has provided that are more specific. And then, of course, there's, negotiating agreements with congressional approval. So there's a lot of paths.
So if you do prevail in this case, what happens next?
The Supreme Court did not take up the issue of injunctive relief, but our clients obviously would be entitled to a refund. It's an interesting question.
What about other people's clients? Just asking for
other
a friend.
People's clients, yes. Well, the government has indicated that it'll honor Supreme Court decisions, so you don't have the situation that you sometimes have in injunctive relief situations, like the court addressed in the Trump versus Casa case just last year, that you've got a district court decision, and the question is, how broadly can they?
Yeah. Can it be nationwide or not?
Can it be nationwide?
Yeah.
The general answer is no, but under the Constitution, when you're dealing with taxes, they have to be uniform throughout the United States. So that actually is a reason why.
And tariffs do as well.
Tariffs are taxes.
Yeah.
And so, yes, so there's a constitutional basis for saying any injunction in this case would need to help everybody. That's not before the Supreme Court, that question. And, assuming the government abides by the decision, and I have every expectation that they will if we prevail, then, I think as a practical matter, I'm not sure you need a nationwide injunction anyway.
Let me come back to something I asked earlier. I want to push on this one again a little bit, which is what you'll be looking for at the oral argument. Is there anything specific? Are there particular justices you're going to be looking at, or are there particular arguments that you're hoping that they'll spend more time on? Or if they're talking about how to interpret the statute, do you think that's a good thing from your client's perspective, or is it more of the doctrine talk that we were engaged in? If you're reading tea leaves ahead of time?
Sure. So, I think our argument that regulate doesn't mean tax that the ordinary meaning of regulate is not to tax, is very forceful. There are hundreds of statutes in the United States Code that would have their accepted meaning would change
Right.
if we're wrong about that. So naturally, the government is and they have said, for example, laws that provide for the regulating of the sale of securities. They've acknowledged that doesn't mean that the sale of securities can be taxed by, say, the SEC. So, they are recognizing kind of the broad implications of that concept.
The hole they dug for themselves here.
Well, they've tried to say that that's why this idea that no, but this language has a particular meaning because it was interpreted that way by the Court of Customs and Patent Appeals back in 1975. Congress was aware of it. They took that soil, put it in the new statute. So that's a way of narrowing. It's kind of an argument that Congress ratified this one lower court decision. And as I've noted, we say, look, that doesn't change the meaning of this statute, especially when Congress has regulated very specifically on the topic of that very case, right? In response to the lower court, the trial court decision in that case, the customs court, it said, okay, we'll give you some specific authority here, but it's very limited. So there's that problem. Then there's the problem of all these things in the opinion. But, we'll be watching, of course, to see what the justices think about that issue and whether they think that, this really is a foreign affairs and national securities case or if it's a taxing case involving the powers of Congress.
I think if they spend a lot of time talking about deference or foreign affairs, then that may not be a good sign. We'll see. But you never know with oral argument. They might be bringing things up just to shoot them down or because they think that another justice is persuaded by that argument and they're trying to get the best arguments to use against them. So you never really know what's going on when these questions come up. But I would be more concerned in that event. Let me switch gears a little bit, Steffen, and this isn't the only executive power case before the court this term. We recently filed an amicus brief in support of the president and his ability to fire Rebecca Slaughter, the now former commissioner at the Federal Trade Commission. Is the question of executive power the same in the tariffs case? I mean, could the president win one case and lose the other? Are these cases going to travel together? How should folks think about this executive power issue across these cases?
Obviously, any outcome is possible in either case, but I mean, in my view, they certainly don't need to travel together because the Slaughter case is about the president's control over the executive branch, and as you
Where
know,
he does have inherent authority.
That's right, and as you know, the president is constitutionally charged to take care that the laws are faithfully executed, and the government is arguing that means that the president needs to have broad ability to remove people who are executing the law under him. And that is his control of the executive branch of the federal government. I dealt with these issues, when I was at OLC. This case is a Youngstown case. That was the steel seizure case again. It's about the president's control over the private sector. Over people, over American taxpayers. It's, for all the rhetoric about how this case is really about
China.
China. My kids would go on a riff about that. But anyway, for all the rhetoric about how, this is about, foreign governments and foreign enemies, it is ultimately about taxing American people. There's no question that taxing can be used for regulatory purposes. If you raise the cost of something, that will have a deterrent effect. And so a tax can serve similar purposes to a regulation, but that doesn't mean that the powers are the same.
Right.
The taxing power and the regulatory power are still distinct powers. They're distinct under the Constitution and they're distinct in the U.S. Code. So I think...
and they're distinct in Supreme Court precedent going all the way back to Chief Justice Marshall and Gibbons v. Ogden and what
absolutely.
have you. So as we wrap up here, Steffen, just final thoughts about the case, anything else that we didn't have a chance to sort of get to here about the significance of this or anything else you want to share with our audience?
Sure. It's a real privilege to work on this case at so many levels. As a matter of its importance, I think it's the most important executive power case maybe since Youngstown, certainly the most important executive power case involving the president's power over civil society over the private sector, over private businesses.
This will be in the textbooks, as they say.
It's going to be right there after Youngstown, I think. So in terms of the importance of the issues to the separation of powers in our Constitution, that's a privilege. More generally, it's kind of an intellectual feast, a case like this. There are so many interesting both constitutional and statutory issues. As a lawyer, you just love to be able to work on cases like this. And then we have a terrific team, starting with my colleague Michael McConnell, my colleague Paul Harold, just terrific lawyers. Our colleagues at Liberty Justice Center, who are terrific, Jess Schwab, Riley Stevens, Sarah Albrecht, and our co-counsel Neil Kochel, who will be at the podium in a week. Just a terrific team of people and terrific lawyers. And, regardless of the outcome, the privilege of being able to work on something of this magnitude, I don't take that for granted.
Well, it's a magnificent brief, and we're really glad that such a strong team is working on such an important issue. I view it as on behalf of the American people, in addition to on behalf of your clients. So glad to see the terrific effort that's been put in there, and look forward to hearing oral argument sometime next week.
Thanks for having me.